Well, now we will speak about that effective... No, well, it naturally follows, because the nature of compensation and the difficulties which Kathleen and Terry have faced trying to obtain it, what are proved to be wrongs. And what does that say? And this is the whole panel initially, but then I'll ask Terry and Kathleen how they feel individually about it. I know Terry's touched upon it. But that absence of a redress directed towards a wrongful act of a state or a state actor, what does that say about the state understanding or accepting its responsibility for its failures?
Well, I think just speaking my experience working with Kath, the government sees no responsibility whatsoever. Well, they saw certainly no responsibility to Kath. So when Kath was released, there was no reaching out. Sue Higginson from the Greens even asked Attorney General Michael Daly, will you be reaching out to Kathleen? And his answer was chilling in its coldness. He said, she can avail herself of the avenues just like everybody else. I mean, I don't know why he would say that. It really comes down to a fundamental issue of belief. They didn't believe Kath. They ought to just be honest about it. And Premier Minns was asked, and he gave an answer which obviously wasn't true, because why would you not approach someone who's been through hell to try and help them and instead say, you can apply? Robert and I, my colleague, a barrister, spent how long, Kath, constructing 300 pages of submissions for the truth-telling aspect, all on the record, all about the police, which neither of the two inquiries went near, or the police prosecutor's conduct, to show them and follow their procedure of that there's no technical liability, but there are errors on behalf of government agents, etc. Kath spent an enormous tiny amount of money she had to get an expert report, and then after hounding them, and I had to attack them on the media. I don't really like being on TV, but maybe you've seen me. But you have to do it, because otherwise there's just they just will keep sending you letters saying it's under active consideration. And then when they finally gave you a paltry sum of money, it was on the day that the Greens and the Nationals, in a rare moment of unity, said, we're calling for an inquiry into this. You know what they wrote to Kathleen, or to me? We hope this helps you rebuild your life. That was it. That was the culmination of the years of struggle just for compensation. And then when we were using the media as an avenue to try and encourage them out of their dark hole to say something, they said that Kathleen, the Premier, Chris Minns, said that Kathleen was demanding money. Demanding money. And what else?
And we were simply following their guidelines that they set and instructed us to do. So that's what made it so, hypocritical to us and hilarious, really. I said, so it's a long, drawn-out process. There's nothing simple about it. And the ex gratia payment, yes, it's true. They refer to it as an act of grace. Well, it's not. It's a monetary version of, can you just please go away? We don't want to deal with you anymore. I said, so I don't know, you're going to touch on the compensation bit, and I'll talk a bit more about that later. But
well, I'll do that right now.
Oh, yeah, do that.
I'll do that right now. So, look, firstly, Kathleen, just because you're closest to the mic there, can you share for the audience what the compensation process was like for you? And secondly, what you would like the decision makers, you wish the decision makers understood about what you were going through and what it was like for you?
I think that, for me, most people who are chasing compensation for this sort of thing, it's not about the money. It's sort of like we might go for the compensation because it's an expected thing to do after you've suffered such a thing. People can fall down and go to break their ankle and get compensation. Why can't I get compensation for nearly 8,000 days in no offence, sir, in jail, sort of thing, in a place that I shouldn't have been, copying everything that I did. To have a person in jail, I think we worked out a rough figure. They say something like it's $100,000 a year to keep someone in prison these days.
More than that.
Bit more than that now. Oh, and I was, sort of thing. I said, so to say that you haven't got any money and you can't pay any more than this, when it's cost them millions and millions of dollars to keep me there, and millions of dollars of poor taxpayers paying for everything that I tried to do, is pretty much you just get a wet fish and slap me in the face then, I said, because that had the same effect. It was made like the Sky payment was, yes, it was like pulling teeth to try to get them to actually do it. I would like to think that anything like that should be an automatic process. Like you were wanting to hope that if you're going to go to the CRC with something like this, that one of the things that they can try to reform or help change is that someone who's exonerated and gets out of prison and has proven that they shouldn't have been there, that it's an automatic payment thing done. No chasing it up the yellow brick road, no, and I think if they did that, you'd find more people probably wouldn't be trying to get the big double-figured $1 million figures out of them. I said because they would be automatically just going, okay, terribly sorry about that. Here's what it was worth each day for you to have been in there. And then you would make the decision whether you go any further.
You're speaking about a payment which also corresponds to an acceptance of fault by the state.
Yes. Now they can dress it up any way they like, but even the scholarship payment as an act of grace and offer that payment like that, to me that equaled, okay, we might have done something wrong here, let's give you this. It said, so it is an admission of sorts that they got something wrong, that the State Department was a hand in it, But to then just be verbally and putting block roads up, I had to accept that scholarship payment because basically with Minns being out in the media and saying what he was saying, he was therefore cutting off on purpose any avenue I had to go and do a compensation claim of any sort, because the only way to do it in New South Wales is malicious prosecution. So they're saying, nothing to see here, there's no malicious prosecution, everything fit as to per the evidence that was presented. I said, so therefore I had no chance of going into a court in New South Wales. And I shouldn't, I shouldn't have had to, so I think the state government had control of my life long enough by then. I really wasn't, ready to let them do it again. They can get the tax out of me. That's all they're getting from now on. So, to have such an uphill battle with it, I would like to hope that we can, in the reform sides of things, hopefully change that so that if any future person goes, and is wrongfully convicted, they're not suffering that extra assault. And it's basically an assault. You may as well just call it that. It's like, I fought we all fought for 20 odd years to get me out. And then you go and insult and assault even further by saying your 20 years was only worth this much money, too bad for you, sort of thing. And I'm supposed to, and you can go see the state. And I'm sort of like, I don't want to go and see the state. Why can't you just be fair? And honest and true about stuff. Don't be,
It represents the essential problem in proving malicious prosecution. Now, Terry, I asked the same question of you. And I can ask it again if you like. Particularly how the compensation process affected you. And secondly, and I know you've touched upon that already, but secondly, the message you would send to a decision maker, if you could, about that process.
I guess I was just trying to process what you were saying, because there was more than one process. I had to go through several. It's like, I've used the analogy of an umbrella with all its segments. Even though they serve the same purpose, like a Department of Justice, each one is separate, each and of itself. And no one's going to put a hole in the umbrella on the other side. The difficulties that you face with it, Michael probably is better at talking about that. My personal issues were making sure all the dots were, the T's were crossed and the I's were dotted, because I came to learn that if I was unable to express myself in a clear, concise way, the message wouldn't be heard. I tried to speak it. I tried in the Court of Appeal, unrepresented. Had no luck, not luck, but I assumed that the judges would be assisting because I was unrepresented after the refusal of legal aid. I was mocked because I submitted a one-page submission on an appeal against conviction because I didn't know any better of what was needed to it. There was no education in the prison. Nobody that I spoke to in Stewart Jail had ever been to the High Court. Nobody had ever been out of Queensland. You know, there was no understanding or knowledge of the law. So to get back to the compensation question, I guess to make an assessment of the damages should not just involve the person who experienced that, because there's family. You know, there's a life that goes on, and I don't think it's sufficient. I think, you know, compensation, I really, you know, for mine would be a better system. You know, that would be a way to do it. Michael's more better at speaking than me, but that's...
Well, I don't know about that. Look, we had the experience with the compensation after Terry was exonerated by the High Court. I thought, well, he's been appallingly treated. I've got a very strong judgment from the High Court. I'll write to the Attorney-General and suggest that ex gratia payment is appropriate in this case. We got no answer. Sorry, wrote again, got no answer. And then it was running up to the 6-year statute of limitations expiry time, and I realised I'm not going to get an answer here. We're going to be out of time to file an application. So I immediately put in, it was so long ago, it was an old, before the Uniform Civil Procedure Rules, it was the old style plaintiff summons.
You're asking the wrong barrister. I can't help you with that.
You're too young. But we never got an answer, but what we did was we then wrote to the United Nations and said, hey, hang on, this guy's been wrongly convicted and he should be given some compensation. The UN wrote back to us and said, well, look, the facts laid out in the communication, which haven't been contested by the state party, show that Mr Irving was subject to manifest injustice. It would therefore appear that Mr Irving should then be entitled to compensation. So we've got the High Court giving a blistering view of how Terry was suffered a miscarriage of justice. We've got the United Nations Human Rights Committee saying, well, look, he should be entitled to compensation, and still the Queensland government didn't do anything. So there was no other option but to continue with the civil claim, as Rani said, for malicious prosecution. It took us, I think, 14 years to get that through the court because it was opposed at every stage. We had ridiculous levels of opposition, and I remember Stephen Keim appeared for us one day in the court, and we had to put on an application to replead something or other, and the Honourable Counsel for the Crown Solicitor stood up and said, we either neither oppose nor consent to the application, forcing Stephen to spend a day in court going through affidavit, reading affidavit, wasting time. We're not going to consent to it because we just don't have to. So I'd like to just contrast this, and I won't take long. I'd point to the difference in the different jurisdictions. In the ACT, they have adopted into their domestic laws, I think I mentioned, the Article 14.6, which allows a right of compensation for persons who've been wrongly convicted. And David Eastman, who was, as you may recall, was sent to prison wrongly for the murder of a police commissioner, he was awarded $7 million of damage after 20 years. I don't say that that's an adequate compensation, but compared with what Terry has been offered, compared with what Kathleen's been offered, and I was talking to Estelle Blackburn earlier about what Darryl Beamish and John Button were offered in Western Australia, both under $500,000 for 20 years, I think, in Beamish's case, Button a few years less. It was quite ridiculous. But what happened in the ACT was that Mr Eastman was able to rely on that UN covenant as accepted under ACT law, and there was a statement, a very powerful statement made by Justice Elkim, which is I call it the Eastman principle, and it refers back to the Wilmington versus DPP the web that runs through the golden thread that runs through the web of law. And he says the plaintiff started off as an innocent person, that is Mr. Eastman. He then became a convicted person. In August 2014, he returned to being an innocent person when he was exonerated. His conviction was unequivocally reversed. The plaintiff's conviction was quashed. He returned to being an innocent person. Now, we had a lot of talk about innocence before. And, do you have to prove your innocence? You don't have to. This is good law in Australia at the moment. Of course, it's the only judicial open we have on the issue anywhere. But it's good law in Australia, and this issue of innocence, I think that is the formula that we need to apply when we're talking about CCRC. But I just make that final point that Eastman was able to recover damages at law, unlike Kathy or Terry. It's not to say that he was able to recover it because it was a CJC, but he would have got there a lot quicker had there been a CJC after he was locked away and refused his appeals. What we should be doing, therefore, is looking to that definition of innocence that we were grappling with before as a method of defining what we would see as innocence. So why do we have different systems of compensation in Australia that are so different and so difficult for some people, depending on where you live? Eastman would not have got a penny if he was in Queensland. Terry Irving would have got millions of dollars had he have been wrongly convicted in the ACT. It's just straight wrong. It's illogical and unfair.
And thank you, Michael.